that the trial of civilians in military courts should ensue in very exceptional circumstances and in conditions that genuinely abide the dictates of Article 14 of the ICCPR. It was in January 2006, supplemented with the draft principles governing the administration of justice through military tribunals. The draft principles on military tribunals were rooted in the 1984 General Comment number 13 and must now be construed with due regard for the committee's revised position as encapsulated in the 2007 General Comment number 32. General Comment number 32 demonstrates that the Human Rights Committee does recognize the trial of civilians in military courts, albeit in exceptional circumstances and within established parameters. It calls upon state parties to guarantee the fairness, impartiality, and independence of such trials, which in any event would only be justified in exceptional circumstances and for serious and objective reasons, with appropriate regard for the suitability of civilian courts for the individuals and offenses in question. That is the universally established command of Article 14 of the ICCPR. Courts martial are established by the UPDF Act by dint of Article 210 of the Constitution to preside over the service offences defined in Section 1 of the UPDF Act, which include the offences enshrined in Part 6 of that Act. The intricate nature of the service offences they preside over supports the view that the primary function of courts martial is indeed to foster the efficacy of the military in securing the country and its borders. The enforcement of discipline within its rank and file is a vital component of that objective, but is certainly not the sole function thereof. Be that as it may, the main bone of contention as far as the jurisdiction of the General Court Martial is concerned appears to be the status of that military court in the national judicial system. Black's Law Dictionary defines a competent court, which is interchangeably referred to as a court of competent jurisdiction, as I quote, a court that has power and authority to do a particular act, one recognized by law as possessing the right to adjudicate a controversy, close quote. In the matter before the court presently, the juridical competence of courts martial can be deduced from the definition of a court in Article 257(1)(d) of the Constitution as juxtaposed against Articles 123(b), 137(5), and 257(2)(a)(1) of the Constitution. I find fortitude for this view in the case of Attorney General versus Joseph Tumshabe, where this court adjourned the General Court Martial to be a subordinate court. I therefore abide the position in the lead judgment that the General Court Martial is a subordinate court of judicature within the confines of Article 129(1)(d) of the Constitution. However, the respondent extends his displeasure to the legislature, faulting it for supposedly exceeding its legislative powers when it created the General Court Martial under the UPDF Act and conferred it with criminal jurisdiction over non-military persons and civil offences. Parliament has a broad legislative mandate under Article 79(1) of the 1 and 3 of the Constitution to enact laws in the interest of national peace, order, and good governance. Article 210(a) and (b) further empowers Parliament to enact laws that govern the UPDF's organs and structures, as well as its discipline. Having found that the General Court Martial is indeed a subordinate court of judicature, it follows that its establishment under the UPDF Act and the delineation of its jurisdiction therein was well within the remit of Parliament. However, the scope of that jurisdiction is a matter of contention before this court. I find that the term service offense in Section 1 of the UPDF Act would encompass the offenses created under Part 6 of the UPDF Act in relation to the persons delineated under Section 1171A to F of that Act, as well as offenses under any other act that are committed by the same category of persons. Hence, the scope of service offenses in question restricts the inclusion of civil offenses to those cases where the civil offenses are committed by persons that are in active military service as delineated under Section 1171A to F of the Act and on field operations. Persons that are not in active military service but only became subject to military law by dint of subsection 1171G and H of the Act would not be tried for service offences in the military courts. I now turn to the contentious question of the jurisdictional scope of the General Court-Martial over civil offences. I do acknowledge the position taken in Attorney General versus Joseph Tumshabe that there is no provision of the Constitution that restricts Parliament from vesting a subordinate court with jurisdiction that is also within the purview of the High Court. For present purposes, however, I take the view that this lacuna should be interrogated with regard to the special character of courts martial and existing international safeguards in respect of military courts. Principle 8 of the Draft Principles of Military Tribunals considers crimes committed in the course of field operations to be sufficient justification for the trial of civil offences by military courts. Indeed, Section 198(2) of the UPDF Act does recognize the function of field courts martial in presiding over offences committed in the course of field operations, I quote, where it is impracticable for the offender to be tried by a unit disciplinary committee or a division court-martial, close quotes. This position is reiterated in Section 177 of the Act, albeit with additional emphasis on a civil offence translating into a service offence, whether committed within or outside Uganda. I am alive to the character of courts-martial as special courts that are set up to address a specific area of the law, having a more limited jurisdiction than the courts of general jurisdiction, being faster and often not bound to follow the same procedural imperatives, and field court-martials are particularly characterized by quick processes that are not unduly bogged down by the procedural imperatives that obtain in general jurisdiction civil courts, or indeed other courts-martial, given the peculiar conditions within which they operate. Indeed, the Constitution recognizes the peculiarity of fields court-martial when in Article 137(5), it exempts their processes from constitutional references. In those circumstances, closing such field courts-martial with jurisdiction over capital offences that attract a potential death sentence might appear gravely ill-advised, but for the following two critical conditions. First, to restrict field courts-martials to non-capital civil offences would be to leave capital offences that are committed in those sometimes fluid situations uncatered for and unaddressed. This indisputably would be inimical to the administration of criminal justice and an affront to the rule of law, which subjects all persons to the law. Secondly, Principle 17 of the Draft Principles on Military Tribunals is emphatic on the right of appeal from courts-martial, which by extension would include field courts-martial. Accordingly, the right of appeal from the decision of a field court-martial does provide a vital safeguard to the exigencies of their judicial processes. Its relegation to creation by subsidiary legislation is a misnomer that ought to be revisited. In the event, I would abide the proposition in Principle 8 of the Draft Principles on Military Tribunals that the circumstances under which field courts-martial operate do provide sufficient justification for their jurisdiction to try civil offences, including capital offences. Having so held, and considering that the General Court-Martial sits in appeal over decisions of field courts-martial, I would refrain from excluding civil capital offences from its jurisdiction. I now turn to the constitutionality of Section 1171G and H of the UPDF Act. The controversy as to the constitutionality of those statutory provisions has arisen in numerous cases with varying results. It now falls to this court, under the present appeal, to pronounce itself with finality on the matter. The fundamental question is whether the parameters that are encapsulated in Section 117, 1G and H amount to exceptional circumstances that would justify the trial of civilians in military courts. The law is a major component of public policy and would thus be vital public policy consideration for the justification of the trial of civilians in military courts. Indeed, I am alive to the duty placed upon Ugandan citizens under Objective 29 and Article 3(4) of the Constitution to uphold and defend the Constitution and the law. This perhaps explains why criminal law considers a person that aids or abets the commission of a crime or has a common intention with others in the commission of a crime is criminally culpable. Reading Section 1171G of the UPDF Act, together with Section 191C of the Penal Code Act, offences delineated in Part 6 of the Act, would be deemed to have taken part in committing the offence, be guilty of the offence if proved, and may be charged with actually committing it. In practical terms, Ayume Francis in criminal their independence and impartiality. In the matter before us, the respondent, having pointed to the impugned Section 195 as the legal basis for his misdemeanor before the General Court-Martial, the evidential burden shifted to the appellant to factually demonstrate the independence and impartiality of that court. Regrettably, such evidence was not forthcoming. I do not accept the appellant's proposition that military courts in Uganda are impartial and independent simply because Article 221 of the Constitution enjoins the UPDF to observe and respect human rights in the performance of its functions. In my view, that constitutional imperative is simply a directional standard for courts martial rather than a factual situation that pertains to them. Consequently, in complete agreement with the lead judgment, I find that the Constitution of the General Court-Martial does compromise its independence and impartiality as a subordinate court of unlimited jurisdiction and is to that extent inconsistent with Article 28(1) and 44(c) of the Constitution. In the result, I would resolve ground 2 of this appeal in the negative. On the other hand, under ground 3 of the appeal, the respondent's arraignment before the General Court-Martial is specifically challenged on account of the omission in the charge sheet to indicate his role in aiding and abetting the commission of a service offence as contemplated under Section 117(1)G of the UPDF Act. As was earlier observed herein, a person that aids or abets another in the commission of an offence is deemed to have taken part in the commission of the offence and, if proved, would be guilty of that offence. In the instant case, an incomplete charge sheet was annexed to the affidavit in support of the petition as Annexure A. It reveals that A1 to A8, with whom the respondent was arraigned, were at the time in active military service and therefore automatically subject to military law. The respondent, on the other hand, is depicted as a civilian, a member of the 10th Parliament of the Republic of Uganda, representing Nakawa Division in Kampala District, and designated as a person subject to military law by virtue of Section 119(1)G, 117(1)G of the UPDF Act. Under count 1 of the charge sheet, the statement of offence is stated as offences relating to security, contrary to Sections 131F of the UPDF Act, while the particulars of offence indicates that the respondent, together with 22 other named persons and others still at large, between the months of February and June 2016, in diverse places in Wakiso, Kampala, and Luwero districts, with intent to prejudice the security of the defense forces, contrived a plot to overthrow the government of Uganda by force of arms. Close quotes. Although the charge sheet referred to in Section 117, I'll say that again. Although the charge sheet referred to Section 117(1)G of the UPDF Act under the description of the respondent, it did not spell out his role in the commission of the alleged service offence. This would indeed amount to a defect. However, not every defect in a charge sheet would make it bad in law and render the ensuing proceedings a nullity. The test to be applied is what the effect of the defect is and whether, if proceedings are concluded, it has occasioned a miscarriage of justice. In this case, no attempt was made to demonstrate any such miscarriage of justice. On the contrary, insofar as the charge sheet highlights the statutory provision that brings the respondent under military law, which is clear on the issue of aiding and abetting the commission of a service offence, the respondent would have been on notice of the nature of offence he was arraigned for. Furthermore, the charge sheet spells out the principal offenders by highlighting their status as persons in active military service. Moreover, borrowing from the civilian courts, under Section 132 of the Magistrates' Courts Act, a court that is faced with a defective charge has a wide discretion to amend it at any stage of a trial. As a similarly subordinate court, that option of amendment of the charge would have been available to the General Court Martial to clarify the specific role played by the respondent in the alleged offense, as well as demarcate who of the persons he was arraigned with were the principal offenders. Consequently, given the procedural reliefs available to him, I do not find the defects in the charge sheet in this case to constitute sufficient reason to declare the respondent's arraignment before the General Court Martial a violation of the right to a fair trial. However, given the then de jure composition of the General Court Martial under Section 195 of the UPDF Act, the respondent's arraignment before that military court cannot have been in accordance with the right to a fair trial before an independent, impartial, and fair court, as envisaged in Article 28(1) of the Constitution. I would accordingly resolve ground 3 of the appeal in the negative. This brings me to what would be appropriate remedies in the circumstances of this case, and whether or not they should apply retroactively. Black's Law Dictionary distinguishes true retroactivity from quasi-retroactivity, the former consisting of the application of a new rule to matters that were completed before the rule came into force, and the latter entailing the restriction of a new legal rule to matters pending completion. In Griffith versus Kentucky, the U.S. Supreme Court reiterated its view in United States versus Johnson on the need to apply a new constitutional rule to all criminal cases pending determination in order to uphold basic norms of constitutional adjudication. That case was cited with approval by the Constitutional Court in Mabea versus Attorney General, and I still consider it to be good law. I would thus equally cite with approval the observation in Duke Mabea versus Attorney General that a new constitutional rule in the realm of criminal procedure be applied quasi-retroactively or restricted to cases pending final disposal to avert the dire effect on the rule of law and the administration of justice of full retroactivity. Griffith versus Kentucky additionally posits that unlike the legislature, it is not the function of the judiciary to formulate laws on a broad basis, its role being limited to the declaration of a new rule directly arising from adjudication. This is similarly acknowledged by the Canadian Supreme Court in the case of Skakta versus Canada. That case was relied upon in Fish-Eric in the article Choosing Constitutional Remedies by Fish-Erickson. The choice of appropriate remedy between severance and reading in, where a statutory provision violates the Constitution, hinges on whether the nature of the constitutional inconsistency entails something improperly included or excluded from the statute. In the matter before us presently, Section 195 excludes such professional competencies in the membership of the General Court Martial as would mitigate connotations of partiality and non-independence. As such, reading those omissions into that provision might have been the more appropriate remedy, but for the fact that the deference to the competence of persons with a military background was at the time informed by the scarcity of legal professionals in the military, as well as the complexities of securing legal professionals for field courts martials. This is borne out by the parliamentary debate in respect of the then Uganda People's Defence Forces Bill, as reported in the Hansard of that time. So that reading into Section 195 of the UPDF Act, the constitutional safeguards and membership as the court deems appropriate would be tantamount to the usurpation of Parliament's legislative function by judicial overreach. However, the same SACTA case proposes another constitutional remedy that gives the legislature a chance to craft its own solution. Provision for legislative reform therein would, in my view, address the shortfalls of the previous legislative process and provide an opportunity for the review of the military justice law in Uganda, as has been done in other jurisdictions. This would align it with the independence and impartiality safeguards envisaged in the right to a fair trial under the Constitution. It will suffice to observe here that unlike judiciary-driven reforms that ought to be restricted to matters that were in contention between the parties, legislative reform may holistically address matters that were not necessarily in issue before this court. It might similarly accrue to the right to a fair trial in courts martials. This would forestall avoidable litigation in respect of related matters and abide the notion of judicial economy. Disposition. The upshot of my judgment is that this appeal partially succeeds while the cross appeal fails. I do abide declarations 1, 2, 3, and 6, orders 3 and 7, as well as the advisory orders D, E, and H as stated in the lead judgment. In the result, I would set aside the judgment and orders of the Constitutional Court and substitute them with the following declarations. 1. The General Court-Martial is a subordinate court of competent jurisdiction within the confines of Articles 129(1)(d) and 257(1)(d) of the Constitution, but its de jure membership under Section 195 of the UPDF Act does undermine its independence and impartiality and is to that extent inconsistent with the fundamental right to a fair trial enshrined in Article 28(1) and 44(c) of the Constitution. 2. The respondent's arraignment before a general court-martial, the de jure membership of which does not pass constitutional muster, was a violation of his right to a fair trial and to that extent is inconsistent with Article 28(1) and 44(c) of the Constitution. 3. The provisions of Section 117(1)(g) of the UPDF Act do delineate exceptional circumstances that would justify the trial of civilians in military courts and is to that extent consistent with the right to a fair trial as enshrined in Articles 28(1) and 44(c) of the Constitution. 4. Section 117(1)(h) of the UPDF Act is void for vagueness and therefore inconsistent with the right to a fair trial as enshrined in Article 28(12) of the Constitution. 5. Service offences as defined in Section 1, as well as the provisions of Section 177 of the UPDF Act, are not at cross purposes with either the objective of the UPDF Act under Article 210 or the legislative mandate of Parliament under Articles 79, 129(3) and 210 of the Constitution, nor in any case are they inconsistent with Articles 28(1) and 44(c) of the Constitution. I shall pronounce my final order as the quasi-retrospective application of all cases pending before the General Court-Martial in light with Order 2 above. I would respectfully propose the following additional advisory order for consideration. The General Court-Martial be substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court-Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order.
Councillor Laka, during my time, you would have the decency of bowing to a judge.
My Chief Justice, we are about to stand because we are so much obliged. We are much obliged, my lord.
Thank you. Can we have Lady Justice Catherine Bamugemereire deliver her judgment?
Thank you, my Lord Chief Justice. I have had the opportunity to read the draft opinion of the Honorable the Chief Justice. He ably sets out the questions for determination before us and has cited the relevant sections of the UPDF Act, Cap 330, and the related constitutional provisions which are said to have been contravened. Please note that the sections of the law I will be quoting are quoted from the immediate past laws of Uganda volumes and also from the most recently published edition. So in my final judgment, you'll find two versions of laws. When I read them, I'll read the one that was probably cited during the hearing. I would allow this appeal in part. The Attorney General lodged an appeal against the decision of the Constitutional Court dated 1st July 2021. The respondent had challenged the competence of the General Court-Martial to try civilians under the Uganda People's Defence Forces Act, alleging that the continuance of these trials violates constitutional provisions, including Articles 28(1), 44C, and 210 of the Constitution of the Republic of Uganda. The Constitutional Court, being the court of first instance in constitutional matters, heard the petition and decided that the General Court-Martial is a constitutionally established court set up to handle cases of military discipline for the UPDF members, but lacks jurisdiction to try civilians for offences under the Penal Code or other enactments. As a result, Sections 2, which now of constitutional right to a fair trial, which should be available to all human beings, including men and women who serve in the military. This entails a delicate balance on a constitutional landscape which the courts are obligated to navigate. I have, in my judgment, undertaken a synopsis of the historical evolution of courts-martial in order to locate their relevance and effect in our current systems. In this, where 1 in 10 soldiers were executed for collective disobedience. Collective disobedience included such offences as mutiny, and mutiny included offences like tree-sitting, sabotage, among others. Tree-sitting meant that the rank and file of men in the mutiny would choose to sit under a tree and not do any work. Annihilation was the extreme measure historically used to enforce discipline in the rank and file of the Roman army. In the latter years, the Normans emerged following the Romans. The Normans, or the Normandy, introduced trial by combat to settle disagreements over money or chattels, movable or immovable, including land. Participants engaged in physical combat until one was killed or too wounded to continue. The loser was hanged, reflecting the belief that God had found them guilty. This particular practice of combat was outlawed in the 19th century, with survivors being charged and tried for criminal offences. One of the Normandy kings, William the Conqueror, developed military justice and influenced feudal traditions in the United Kingdom, including duels and, again, trial by combat. The duel significantly influenced modern culture. The duel combat today, it came from the shire courts. Under William the Conqueror, the principle of resolving disputes within the military hierarchy persisted and influenced courts-martial. We'll then go to King Gustavus Adolphus. King Gustavus Adolphus of Sweden formalized military justice with his 167 Articles of War, introducing regimental and standing courts-martial to enforce discipline and morality. These systems were credited with fairness and morality and helped Europe and the British military laws, and up to date, there are military academy known as the Gustavus Academy. The Soviet Union. The Soviet Union discipline of its rank and file was enforced through punishments, awards, incentives, and enhanced patriotic zeal. Severe discipline was demanded. The punishments in the Soviet Union included drinking restrictions, surveillance, counter-surveillance, and even physical searches. One of the most notorious infractions a Soviet soldier could commit was drunkenness. The persistent inspection and searches of the soldier military personnel frequently made it difficult to smuggle alcohol into their garrisons and posts. A non-fiction writer identified alcohol as the primary cause of disciplinary infractions in the Soviet armed forces, resulting not only in drunkenness, but also in theft, bribery, record falsification, and deliberate damage. Alcohol was used not only to deaden the senses and allow a period of escape from the hardships and pressures of daily life, but was also used to celebrate and commemorate every event. Soviet soldiers and sailors were supposedly only permitted to drink when expressly allowed in accordance with the regulations. The Soviet soldier drank when the opportunity to drink presented itself, in direct violation of disciplinary restrictions. They were so starved of drinking that they resorted to drinking the eau de cologne, eating shoe polish when vodka was unavailable. This infraction, though minor, could lead to severe punishment, including imprisonment or banishment to Siberia. The British military system, originating from the medieval court of the chivalry, involved tribunals. The decline of the court of chivalry led to councils of war, which addressed offenses such as mutiny and desertion. They enacted the Mutiny Act of 1789, which established a legal framework for the courts-martial, ensuring discipline while introducing procedural safeguards. Key issues included the struggle for control over the military justice system and the development of military due processes. The American military justice system originated during the Revolutionary War, drawing heavily from the British military codes. Post-World War II dissatisfaction with the wartime military justice led many Western countries to adopt more judicial approaches and procedures in their military justice. The American military justice has often seen the intervention of the US Supreme Court in military matters. The question of the status of the offender are constantly under review. A status of the offender determination by the courts helps in restricting which offender is liable to appear and be tried before a court-martial. Often, the spouse or dependent of a serving officer and a civilian worker connected to the military either lose or have their day in court when found offending. The cases of Milligan or Callaghan, Kinsella, and Curry are but a few examples of judicial review of military justice. The determination of what amounts to peacetime and wartime offenses are interrogated by the civilian courts. Uganda's military justice system. Uganda's military justice system was influenced by British military law, partly because we were colonized by that country. Fast forward, the 1975 Economic Crimes Tribunal, established by the government of the day between 1971 and 79, was established to punish profiteers, hoarders, and others acting against the state's economic interests, with penalties including death by firing squad or imprisonment. During the period 1971 to 1979, military tribunals often tried civilians and soldiers alike with little regard for fairness or due process. The system was highly politicized, with military tribunals taking precedence over the civil courts. In its military institutional framework, Uganda borrows heavily from the British, the American, and indeed the Soviet or former Soviet states militaries. We have offices such as the judge advocate and the political commissar, which are vestiges of our non-aligned associations with those countries. I will now move to the matters at hand. Notably, the provisions in Section 119 are at odds with the constitutional guarantees under Chapter 4 and 8 of the Constitution of the Republic of Uganda. The current status of courts-martial in Uganda is that all officers who sit on the General Court-Martial are serving army officers who are appointed by the High Command and are men under authority at all times. This means that the setup of the military courts does not follow a process that gives assurances that they will be independent and will deliver justice without fear or favor. By the very nature of their appointment, the structure and the reporting lines, courts-martial are firmly under the superior command and possible instruction of their bosses. Articles 21 and 28 of the Constitution, which provide for equality before the law and a fair trial, offers the following guarantees. Guarantee for equality. Equality means that all persons who appear before a tribunal or court of law are treated equally regardless of their race, their gender, age, or other factors. Presumption of innocence. That an accused is presumed innocent until proven guilty. Burden of proof. That the prosecution must prove its case beyond reasonable doubt. An independent and impartial tribunal. The trial must be conducted by an independent and impartial tribunal. Opportunity to present evidence. The accused is granted the opportunity to present evidence and to challenge the prosecution's evidence through cross-examination. Right to an interpreter. That the accused has a right to an interpreter if they cannot understand the language being used in court. Protection from self-incrimination. That the accused has protection from being forced to incriminate themselves. Right to a public hearing. That the trial shall be open to the public. Right to be represented by a lawyer. That the accused has the right to be represented by a lawyer of her choice at all stages of the trial. I have found that the determination of the jurisdiction of the courts-martial attracts investigation of the legislative intent of creating it. And I ask the question, was it the intention of Parliament to vest the courts-martial with jurisdiction to try only serving officers for committing a service offense, or was it their intention to extend military jurisdiction to civilians? Reverting to the long title of the UPDF Act, it is clear that the application of the law was intended to be restrictive rather than general, as it specifically states that it is an act to regulate the Uganda People's Defense Forces. To this end, Section 197 of the UPDF Act also states clearly that there shall be. How does this stand with that it is constitutional to create and have general court-martials? Historically,